Next up on This Week in Law, we've got our last episode of the year. We're going to bring you the best macaques and drones of 2014. And we wish we were a drone flying over the Garcia versus Google Ninth Circuit en banc argument, because it was replete with orcs, Celine Dion, and human cannonballs. We'll tell you about all that and much more next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell, episode 286, recorded December 19, 2014. Litigious Orcs and SOPA Zombies. This episode of This Week in Law is brought to you by Blue Apron. Blue Apron will send you all the ingredients to cook fresh, delicious meals with simple step-by-step instructions right to your door. See what's on the menu this week and get your first 2 meals free by going to blueapron.com/twit. That's blueapron.com/twit. And by FreshBooks, the simple cloud accounting solution that helps millions of entrepreneurs and small business owners save time billing and get paid faster. Join over 5 million users running their businesses with ease. Try it for free at freshbooks.com/twill. Hi, folks. I'm Denise Howell, and thank you so much for joining us for our final episode of This Week in Law in 2014. We have a phenomenal panel joining us today. In fact, I have a wonderful introduction to make, not her first introduction to the show because she joined us back on episode 272, but we've already announced on Twitter and elsewhere, but now I get to formally announce on the show that Sarah Pearson is going to be joining me as our co-host of This Week in Law starting after the first of the year. She won't be on our very first episode in 2015, but shortly thereafter, she'll be coming on board on a regular basis. And she's here with us today. Hello, Sarah.
Hi. Hey, Denise. I'm really excited and actually a little bit terrified about this, but I think it'll be a lot of fun and I'll learn a lot. So I'm excited.
Absolutely. I am so excited and not terrified at all. I'm so glad to have you joining us. And nor am I terrified about any of the rest of our panel today. I don't think you will be too. I think you're going to really enjoy the folks that we're bringing you here at year end. The first of those people is Margot Kaminski. Hello, Margot.
Hi, Denise. Thanks for having me again.
Great to have you back on the show. Margot has shifted gears since the last time she joined us. At that time, you were still the executive director of the Information Society Project at Yale, Margot. But now you're over at Ohio State University, teaching and researching and doing scholarship there. And we're thrilled that you could take the time out to join us today.
Yeah, this is right in the beginning, middle of our exam period. So it's an exciting time for all of our students.
Yes, that's one way to put it. Another fellow who's not at all unfamiliar with the arduous process of being a law student once upon a time is Jake Heller, the founder of Casetext. Hello, Jake.
Hey, how's it going? Happy to be here.
Great to have you here, Jake. Could you tell us real quickly about Casetext for people who aren't familiar with the company?
Sure. Casetext, which is at casetext.com, is a legal research website where all the cases and statutes involved have annotations added by a community of lawyers. So what we do essentially is we pull in all the amazing things written by law firms, by bloggers, by law professors on their blogs, and add that to the legal research database, as well as have a lot of information that people have added to the cases themselves. The idea is, if you're doing research on Casetext, you do it with context. You understand what the headlines are about what the case, what's been written about it, and what the most important parts of the case are.
I just love this idea, and I want to talk to you more about it a little bit later on in the show. But there have been a lot of really interesting developments lately that I'd love to get into first, if everyone is game to go. We haven't yet talked about the Sony hack here on This Week in Law, and I think we should, given the news that came out even after sort of our definitive show on the network that covers all things related to hacking and security is Security Now. And the very day after Steve Gibson's show this week, it was learned or announced by the U.S. government that we believe North Korea to be behind the attack. And the New York Times is reporting today that the FBI has come out publicly and said it has extensive evidence that the North Korean government organized the cyber attack that came after Sony. So at least we have someone that fingers are being pointed at. With this panel, I wanted to get into sort of the what now issue. If, in fact, the FBI is confident that they know the identity of the hackers, what sort of legal or other recourses are we looking at, if any? Margot, do you have any thoughts on that?
I think this is an incredibly difficult area of the law and one that I'm not particularly well versed in. I know that the laws of cyber warfare in the international context are really difficult to navigate because it's not clear what counts as an offense. And in this case, you have possibly a state actor going up against a private company. I'm not sure whether the U.S. government is going to want to get directly involved.
Yeah, it certainly sounds like there are a lot of moving parts to it and some delicate diplomatic issues at stake, and possibly some life and death issues at stake with Sony being a Japanese-based company and there being Japanese prisoners held in North Korea. So certainly I wouldn't be surprised if we saw a lot of treading lightly and diplomatically over us. From a legal standpoint, Sarah, I mean, I was talking about this with Keith Stryer, who was on the phone on the show a couple of episodes ago, earlier this week, and we were both just kind of scratching our head and going, so what do you do when you've got a cyber attack by a foreign state? It's not exactly like you can bring them into U.S. court and turn an overzealous prosecutor onto them under the Computer Fraud and Abuse Act, can you?
Yeah, that's right. I mean, I think the enforcement issues are really tough. There's also just kind of the practical issue of if we do something to retaliate, then there might be retaliation back, and maybe that's worse than the original attack. And so I think it's a really tricky area. One thing I read this morning is George Clooney is really speaking out about the precedent that this sets in terms of the ability of hackers or terrorists or anyone to kind of dictate what content we see, what movies and that sort of thing. And I think that's a really interesting point.
Yeah, it sure is. Jake, do you have any thoughts on this?
Yeah, I think there are a bunch of interesting things happening here. One that hasn't been covered a lot, but that gets discussed sometimes when there are hacks like this, is what implications this has for what should be private communications between people like Sony and their lawyers. Now that kind of hacking has become common, I would not be surprised if some of the more interesting releases that come out should be privileged or should have been privileged. And we may find in the coming weeks, as has happened in previous hacks, a lot of stuff that was meant to stay that way ends up getting released by the likes of WikiLeaks or, in this case, North Korea. And I think that raises a lot of interesting questions around what you should and should not communicate to your lawyer, and how secure is that really, and how do you protect the privilege in a context where what should be secure email networks gets hacked. So I think there's a lot of interesting other potential legal issues that might arise from this.
Right. Well, I think that's a fantastic segue into some of the stories that I've grouped for us today under the entertainment topic. All right, let's get into some things that might have been confidential communications between the MPAA and its lawyers, perhaps, that came out, part of the many, many things that have been leaked as a result of the North Korean hack was I'm going ahead and assuming that if the FBI says it's pretty confident that North Korea did it, that North Korea did it. I suppose that people could take issue with that. And it's certainly some question marks went off in my mind as I was reading through the coverage and the justifications. Again, a lot of it is not being released by the FBI because they're not going to tell us exactly how they do these investigations. It's all confidential and matters of national security. But part of the coverage emphasizes over and over again how these attacks resemble other attacks that have been done by North Korea. And of course, one way to make it look like North Korea did the attack is to model your attack after things that North Korea is thought to have done in the past. So, I guess it's impossible to know exactly who did this without knowing who did it. But when the FBI says they're pretty confident, I guess we can be pretty confident. Now that I've gone down that rat hole, let us reroute to talking about things that came to light as a result of the hack. And one of the things supposedly is that the MPAA and others affiliated with it have been working with state attorneys general to pursue investigations, legal investigations, possibly criminal investigations against Google. Margot, what do you make of all this?
This is incredibly fascinating. The relationship between criminal law and something we're going to talk about later, which is private ordering agreements between content companies and internet service providers, is really interesting to me and has been for a while. With the basic idea being that the MPAA thinks that it can get companies like Google to make these agreements with them to filter content if they have a stick in place, which is the threat of criminal enforcement of some kind. So these revelations show that this is actually a deliberate strategy on the part of the MPAA. They've been giving serious campaign contributions to state attorneys general. And in one particularly egregious case, they actually had the MPAA law firm, Jenner & Block, wrote the complaint for the Mississippi State AG. And the document that was leaked in the Sony hack actually has Jenner & Block's watermark on it. So you see them directly getting involved with the criminal state threats against Google as a way of trying to push them towards a negotiating table.
Right. So, Jake, I guess this gets back to your point that if you're, if your corporate competition strategy is going to include lobbying and donations and perhaps ghostwriting briefs for state attorneys general, you're going to have to be quite cautious about how you go about that in the age that we live in today.
Yeah, absolutely. And I actually think we're seeing something that it might be a somewhat unique moment in history, because I think it is possible, before this kind of a bunch of hacking and WikiLeaks and the most recent hacks with North Korea, we kind of knew that this sort of stuff happened. We knew, people thought, that there might be this very close relationship between, for example, state attorneys general and the people that bankroll them. But there wasn't really hard evidence of that. And we're seeing that now, that there very much is, this very close relationship where they're, for example, ghostwriting briefs or letters to Google. And one of the more interesting things I read this week basically said that there's a coalition of companies that include the MPAA, but also Microsoft and others who are backing state attorney general to take on Google for even unrelated matters, just to kind of be a menace. And I think that this stuff will be exposed now, and then later, potentially months or years later, when security is locked down, when we change the protocol for communicating this kind of confidential information, that evidence will kind of disappear again, and so and we'll go back into the dark. So I think now is one of the few times in history where a lot of this information may be really exposed and brought out to the open. Which in some ways, I mean, it really is hard for Sony, and they're in a really tough position. And in some other ways, I think this is actually kind of good for democracy and good for good for our general knowledge of the way that these kinds of things work.
Yeah, I think that was, I was listening to a bit of Steve Gibson's show, Security Now, from this week. And he was having a discussion with Leo about whether there's a positive societal benefit to these leaks coming out. And Steve was of the mind that the only way for security to really get up to the level that it needs to rise is for companies to realize with all of the associated detail the ways in which their private matters can become public. And it sounds like you're echoing some of that here, Jake.
Yeah, a bit. I mean, I wouldn't argue that it's necessarily on balance a good thing. I mean, I feel really bad for the people at Sony. If something like this happened at Casetext, it obviously wouldn't be nearly as much of a scandal. But I completely understand the position they must be in and how hard it must be for them. At the same time, I think that those comments are right. These kind of very public things will make clear that people have to take security a lot more seriously. And it also has a kind of another effect, which I think a lot of people will start doing, going back to not writing things down, doing things over phone calls. There might, you might see products coming out that look a lot like Snapchat, but for, what should be, kind of private, secure communication. So you might send somebody a document and it disappears entirely off the servers in 24 hours. And I think a lot of communications that are now being exposed that are quite embarrassing will, in a lot of ways, disappear again. And like I said earlier, I think we're kind of in a weird and unique moment in history. Kind of like also when Facebook came out, people were sharing just way too much, and nobody really knew what to make of it or what to do. And then people, a lot of people started wising up to it, and they're not, and privacy became a bigger issue there. I think similarly, you're going to see. Right now people are used to sharing information in certain ways, and that norm will change. But as it is right now, a lot of this information that kind of peels back what's really happening, in the relationship between companies and the government, companies and their employees, all that stuff will come out, now, and it should be a really interesting time.
Yeah, I think you just blew my mind on several different levels there. Sarah, do you agree that, my question to you originally was going to be, how will lawyers and the legal profession confront this kind of reality? I mean, certainly we have to communicate with clients. Clients have to communicate with their lawyers, even if they're not engaged in lobbying state attorneys general to go after their competitors. There are a lot of reasons why communications with your client need to stay confidential. And yet there's this tension between doing that and having any kind of convenient modern communication, because it is by nature not necessarily 100% all the time secure. So do you agree with Jake that maybe things will start to self-destruct a la Mission Impossible?
I think it is easy to kind of start to feel a little hopeless about it, in the sense that, we can have new technology that's more secure, but presumably eventually, the hackers will catch up. So you're kind of constantly, it's this chase going on. One solution would be, I guess, for lawyers to start being really, really careful about what they put in writing, which a lot of lawyers already are. But maybe that's one outcome of this, is there's more phone communication for really sensitive things. I don't know for sure what it's going to look like, but it is a really interesting issue.
Margot, do you think that the fact that this has become public will take the wind out of the sails of these investigations in several states?
I worry about that because a lot of the investigations are things that maybe Google should be investigated for. So I'm torn on that front because I do think that, as Jake pointed out, the subject matter of a number of these investigations has nothing to do with where the MPAA wants to pressure Google. It has to do with, stolen credit card numbers or child pornography, which is, the bane of the internet in general, or with privacy violations. So some of the dirtiness of this is disturbing because it will undermine some good causes. I was also thinking in general that this conversation is reminding me a lot of conversations I've heard about reporters and secure communication. And you have a number of old-timey reporters who, now that they are afraid of things getting listened in on the internet, are actually turning increasingly to just direct conversations with sources, which obviously has its own difficulties because we live in a world that's tracked in the real world also. So trying to create the moment where you go and find your source and talk to them in real life can be as difficult as creating a secured platform online. And in the phone context, you had the government seizing the AP's phone records almost, I guess, 2 years ago at this point. So that's not particularly secure communication either.
Right.
So I wonder if this just leaves us in a depressed place where, you're in a world of increasing conformity and less secure, confidential, communicative opportunities.
Well, I hope not. I mean, I think you're onto something with perhaps a parallel to secure drop for confidential legal communications. And, I don't know. I mean, we've seen this week the news of Verizon marketing its product as having secure voice communications, except when the government comes knocking. So, what's secure enough, I guess, is something that businesses will need to work out over time. Something else that's been working itself out over the last year, and I'm so glad we get to conclude our year with the discussion of this case because it's been so fascinating. It's the Innocence of the Muslims case that we've discussed several times on the show, which is in a very interesting legal posture right now. This doesn't happen all that often. Was decided by its trial court. This is the case where the actress was deceived as to the kind of film that she was signing up to do. And she gave a performance and did not realize that she was going to be in this Muslim bashing piece of work, and decided to sue Google to remove the film from YouTube. Have it removed because she claimed she had a copyright interest. And she, I guess procedurally, she must have, and you can fill in the details if I'm wrong here, Margot, she must have initially filed a DMCA takedown notice that was not honored, and that is how she sued. Is that how we wound up in this situation?
I believe so. I know that Google didn't want to recognize her probably properly as the owner of the copyright because she didn't fix her performance. She merely performed.
Right. So she did sue, and the trial court sided with Google and decided that there is no independent copyright interest that the actress had. However, that went up on appeal, and Judge Kaminski and a Ninth Circuit panel decided otherwise. And the only other recourse to that may have been some sort of appeal to the United States Supreme Court. But an interim step that is sometimes taken is to get the entire en banc panel. That means all hands on deck, every Ninth Circuit judge, to rehear and reconsider this decision by the three-judge panel who Judge Kaminski authored that opinion. So that oral argument just took place. Margot, you were part of an amicus brief that was filed by several law professors related to this case. Did you also attend the argument?
No, but I listened to it live streaming and was part of extensive Twitter conversation around it while it was being argued.
Right. So tell us what you think is next in this interesting saga.
So just one quick point, which is that the en banc panel is actually still a panel from the Ninth Circuit, even though it seems like it's every judge in the Ninth Circuit. The Ninth Circuit is enormous. My general sense of the oral arguments was that it really went in the direction of Google. I think that you can't be completely confident about this because there were not that many judges who decided to talk. But the only voice that was really supportive of the actress was Kaminski, who was making a valiant effort to defend his lower court opinion. The thing that's really at stake here is that you have a case where it feels like this poor woman had something terrible happen to her. She's received death threats as a result of being part of this film. She claims that she really legitimately fears for her life. But because Congress has set up this perfectly legitimate and probably good policy judgment-based statute, the Communications and Decency Act, Section 230, she can't get Google to take it down unless it's a copyright claim. So this sort of forced a case that really should be about something else, about the threats upon her life or the fraudulent conveyance to her that the film was going to be about one thing when it ended up being about something else. It's forcing concerns over that into copyright law where it's really not a good fit. So the brief that I was part of basically tried to explain this to the court and said, this is not what Congress intended. CDA 230 really does immunize hosts like Google from these kinds of claims, and it does so because we don't want to have a significant amount of collateral censorship happen where an internet provider tries to take down as much as possible to avoid liability and ends up censoring tons of speech.
Right. So Section 30, if this is permitted to stand, the law professor's brief argued that the lower court or the appellate court's opinion here is actually a judicial expansion or actually contraction of that doctrine and the immunities that it provides. Could you expand on that for us?
Sure. So this would basically, if she's found to have copyright protection in her unfixed performance, then that is going to allow anybody who is anybody depending on how the court defines it, who is a performer in a video to send a copyright takedown notice to Google. And the point of our brief was to say, again, this is not about copyright. This doesn't fit into the usual copyright doctrine of what counts as something that's copyrightable. And so instead, you're rerouting around Section 230's protections for Google and allowing somebody who can't make the defamation claim or fraud claim or right of publicity claim and use that to get Google to take down the material to instead claim copyright protection in it.
There were a couple of good tidbits that the Tech Dirt article covering the argument picked up on, in fact, put it in the headline that this was all about Celine Dion and human cannonballs at oral argument. Can you tell us how those came up?
Sure, this was hysterical. So there's actually a third example that I also want to talk about, which is the Lord of the Rings battle scenes. I never thought I would hear a Ninth Circuit judge talk about the Lord of the Rings and orcs. Anyways, the Celine Dion example was effectively Judge Kaminski asked Google's attorney whether it was fair that Celine Dion should get some sort, it's actually not copyright protection, it's a related protection, but some sort of protection for her performance of her song in a video, where if Laurence Olivier were to act in an entire movie production, he wouldn't get any kind of copyright protection in that. There would be copyright protection in the movie, which is fixed, but Laurence Olivier doesn't have a separate copyright protection in his acting. And so that was the Celine Dion example. And then Garcia's attorney gave this weird description of how things could go terribly wrong if Celine Dion didn't have a way to claim copyright in her performance, because some bad actor down the line could take Celine Dion's performance from Titanic and attach it to, some terrible, scandalous sex movie. And so she was sort of implying that performers have this moral right in their performance to not have it associated with very bad things that they don't approve of. And in the United States IP system, that's just not the case.
Got it. So human cannibals.
Yes. So human cannibals, I'll try to be shorter on this one. Kaminski did this strange thing. So Google's attorney was saying that, and this is true, one of the more difficult parts of the finding that Kaminski made for them is that it fragments copyright in videos in a really terrifying way. So let's say you had a video of the Lord of the Rings battle scene, and let's say it was made with real actors instead of CGI characters. If you allow for copyright in unfixed performances or in the performance itself, then every single one of those actors in that movie scene could conceivably send a takedown notice to Google. So Kaminski's rebuttal to this was that there's a human cannibal, actually right of publicity case from the Supreme Court that found that a 15-second performance was protectable under right of publicity. And Kaminski's point was, if a 15-second performance is protectable as right of publicity, then what's so bad about giving her a performance over her 5 seconds in her video? And Google's attorney kind of stumbled on that because he wasn't expecting a right of publicity case. But the general answer is, right of publicity and copyright are not coextensive, and right of publicity claims fall under Section 230. You don't get to ask for the work to get taken down.
Right. All right. So, Sarah, do you think that perhaps the recourse here should not have been copyright at all?
Yeah, I do think. I think it reflects this larger problem of using copyright to solve non-copyright problems. Mm-hmm. There are lots of examples of that and lots of times it's well-meaning. It's things like revenge porn, these really tough issues. And people will raise the idea of, well, copyright is a hammer that we have, which interestingly, I think it's kind of sad that copyright is the one wrong that we choose that to have this, this enforcement mechanism that has so much teeth more than other wrongs that actually involve personal harm often in a really significant way. But because copyright is that hammer, people often try to use it to get around their inability to deal with other problems. And I think that is not a good thing, definitely.
So what should the actress have done here then?
Yeah, I mean, I think that is the $1 million question. I think that might be the case that she didn't have any recourse under the law. And I don't know that there's anything that we can really do about that. I don't know if Margot, if you have any other thoughts about that.
Yeah, so I think she does have recourse, but she has recourse against the director of the movie, right? She doesn't have recourse against Google.
Right,
so the whole thing boils down to whether you think that in cases where you can't actually get anything from the horrible person who defrauded you, whether you should be able to still take it down from the internet. And at least right now, there are things that are really sad about, for example, the inability of people to take down revenge pornotography, except by evoking copyright. But for right now, that is the balance that Congress has struck. Copyright gets this one system, and every other content has a different kind of system, which is immunity.
Jake, do you think there's some kind of appeal to the argument that, and again, maybe the recourse here is simply against the movie maker and not Google, but the actress's argument here that she had agreed and licensed her performance for one purpose, and that was not the purpose to which it was put. Does that give her an ability to reach beyond just the movie maker on a copyright basis, do you think?
I think I actually agree with what's been said earlier. I do think that her only recourse under law is against the movie director. I actually wonder if there might be a way for her, I haven't given this enough thought to know if this would be a legally sound strategy, but for her to sue the movie maker and say, something along the lines of, the recourse I'm looking for is for you to enforce your copyright in if I win this case against you, saying you've duped me and this thing shouldn't be online in the first place. You weren't under injunction to then ask everybody to take down this movie, because I think I could be wrong about this, but I think he has that right as the creator of the movie, as the actual copyright holder. And that might be another kind of interesting way of getting at what she wants to get at. Essentially, if there is a non-monetary way of compensating her and making up for the fact that she was duped into doing this movie. But I don't think the answer is necessarily copyright. For her to have a direct copyright, right against Google and YouTube, et cetera.
All right. Well, we're getting on to the point where I want to thank one of our sponsors for this episode of This Week in Law, and that is Blue Apron. Blue Apron, you've heard us talk about on the show before, so you might be familiar with it, but in case you aren't, it is a wonderful, wonderful service that's all about making cooking and eating fun. If you're busy and health conscious, or you just don't know your way around a kitchen, cooking can be a chore, and ordering out is expensive and gets quite unhealthy quite quickly. You don't know how long food in a grocery store has been sitting on shelves or how far it's had to travel. But with Blue Apron, it solves all of those problems. It's going to make your cooking fresh, delicious, and absolutely wonderfully gourmet, full of flavors, and easy for you. So it's just the best of all worlds. Here's how it works. You pay just $9.99 per person per meal, and Blue Apron sends you a refrigerated box with the right high-quality ingredients in exactly the right proportions and a simple step-by-step recipe instruction for each meal. And all this comes right to your door. If you're concerned about the environmental impact of the boxes, I've been receiving these and cooking these meals, and everything is biodegradable, and that's all thought about as well. The ingredients are friendly to your local farmers. That's where Blue Apron sources its materials from local farms. You'll be getting produce that's currently in season and at its peak of freshness. Meals, too, are only 500 to 700 calories per serving, so that's pretty darn good. I just ordered a panini sandwich watching the Hobbit movie last night that topped out over 820 calories just for the one sandwich. And I can tell you that these Blue Apron meals are much more hearty and healthy for you than that food choice on my part was. You'd never guess, too, that you were counting calories by eating the meals because they're so delicious. And Blue Apron will work around your schedule and your dietary preferences. Cooking each meal takes about half an hour. There is chopping involved because you're working with fresh food, but really they've made it as easy as possible. All the things are separated out. There's just the right amount of everything. Shipping, too, is always free, and the menu is constantly featuring new recipes. You'll never get the same meal twice, and you'll make meals that you like roasted chicken with latkes, or if I'm saying that right, latkes, or sunchoke and mustard green ragu with crispy torn bread and fried eggs. They get really, really creative, and that's one of the things I love about the service is it encourages you to reach in your cooking a bit, like you would if you were going through a cookbook and finding a fun recipe that sounded interesting and eclectic and exotic. But not only are you doing that, you're getting all the ingredients and the step-by-step instructions how to put together those ingredients delivered to your door. And given that, you'll cook incredible meals and be blown away by the quality and freshness. Blue Apron is fast, fresh, and super affordable. You're going to cook like a gourmet chef. So you should go see what's on the menu this week and get your first 2 meals absolutely free by going to blueapron.com/twit. That's right, 2 meals for free just by going to blueapron.com/twit. Thank you so much, Blue Apron, for your support of This Week in Law. All right, let's talk about blocking. We have a few blocking stories in the news this week. I was kind of had my eye caught by the Roku story. The fact that Roku has been going back and forth with Comcast because it was having HBO Go and Showtime blocked on Roku streaming devices on the Comcast network. All that was kind of reminding me of Google TV and the problems that they had being blocked by the major television networks. This seems like it's going to be a give and take, tug of war kind of situation for the immediate time being and going forward. I'm not quite sure why Comcast would want to block those services on a Roku, but it seems like they have, at least for now, worked something out where the services will get through. Margot, what do you make of someone like a Comcast deciding that if you've got a third-party set-top box that's going to bring things in that compete with television offerings, that those things are going to be blocked? Are we getting into an antitrust issue there?
It's definitely anti-competitive behavior. I don't know if it's going to rise to the level just because our antitrust law has been relatively weak recently. But it definitely should segue us nicely into a conversation about net neutrality.
Mm-hmm. Definitely. And that we certainly should talk about that before the show wraps up. In fact, we could talk about it now if everyone would like. Certainly, we're waiting for the other shoe to drop still. On the net neutrality front, we had some tech companies that just came out against net neutrality. Did you have a chance to take a look at that, Sarah?
Yeah, I read that article. It sounds like it's mainly companies that deal with tech infrastructure. And they were making the argument that we often hear is, that regulation will stifle investment. It's always hard not to be skeptical about those because those claims are so self-serving. But, they're often true as well. So I feel like net neutrality is one of those issues where no matter how many articles I read, I still feel like I have a very superficial understanding of all of the arguments. So yeah, I didn't have much of a reaction,
right,
other than a little skepticism.
Jake, I'm curious on your take on the net neutrality issue, given that you're the founder and CEO of a company who relies on the web to distribute and deliver what it is that you're providing. Do you have an opinion either way?
Yeah, I definitely do. I mean, the thing that scares me as like you said, as a founder of a small internet startup, is without net neutrality, you can have a situation where the very big companies can pay for or otherwise negotiate faster internet connections for their websites, right? So for us, you can imagine LexisNexis and Westlaw paying Comcast and Verizon, et cetera, to have much quicker internet connections, so people using their services would get delivered faster than Casetext, and we couldn't compete in a world because they make billions of dollars a year. We have so far spent under $1 million to develop our product, right? So we're just totally different playing fields, and I think that for that reason it might hurt competition online, and that's the one thing I worry about the most. And actually, I think there's the reason that these big companies offered for why they're against net neutrality, and there probably is some logic there, and there's some reason behind it. But we have to remember, whenever a very big company is arguing in favor or against net neutrality, rather, there could be some thought like, oh well, it's not going to affect us because we can just pay for speed. We will not be the ones affected, and the true people who will be really affected are the people who have very small startups who are just trying to compete with these bigger companies. And that's something that's on my mind when I think about net neutrality.
So one reason that companies might try and block certain content is competition, as we've been discussing. Another is back to our old friend copyright law, and it appears that the MPAA has a strategy for, once again, it's sort of echoes of SOPA, but they plan on, again, as they tried to with SOPA, doing it legally, bringing technology that will block pirate sites to the U.S. that has been in place in other countries for a bit. Margot, can you shed any light on this for us?
Yeah, this is the SOPA zombie. SOPA never dies. So the MPAA, it remains not very satisfied with its privately negotiated copyright alert system, which is a privately ordered agreement between content companies and internet service providers. That internet service providers to give a series of notifications to users that they're infringers, and then eventually ends up, gently maybe kicking them offline. And so the MPAA would much prefer for all of this to take place through the U.S. legal system and actually create a system whereby we directly technically block sites. And the revelation, the leak, or whatever ends up showing in order of priority what kinds of sites they're most concerned about. One of the surprises to me was I think actually that BitTorrent in general is not that interesting to them, relatively speaking. But this discussion of trying to enact new laws around blocking is moving hand in hand with what we discussed earlier, which is the effort to try to use criminal law to go after the companies that the MPAA is not happy about. And with another topic we're going to talk about momentarily, which is the efforts to sue cable companies for failing to terminate repeat infringers' accounts.
Right, which is what Sony, actually, I guess it's just BMG here, is the plaintiff that is coming after Cox in this case. And again, it goes right to that copyright alert system, which sometimes is shorthanded as 6 strikes. I think you go back and forth over whether you get 6 strikes or not, but as it was being developed, that's what we were calling it. And what BMG has done here is go after Cox for failing to terminate a user account. BMG claims that this user had over 54,000 complaints against them about their activity using their ISP, and yet still had a viable account. So now what's going to get resolved in this case is a provision of the DMCA that deals with what an ISP has to do in the case of a repeat infringer. The DMCA will shield an ISP for liability for its users' conduct to some extent, but when there's a repeat infringer, the duties on the ISP's part go up. We just don't quite know, because Congress never defined the term, what it means to be a repeat infringer. So, Sarah, do you have any thoughts about where this case might go?
I don't. I mean, I think it's one of those issues where when you first read the headline, it was 50,000 cases of infringement. Obviously, that's crazy. But I think it's important to remember that DMCA takedowns are just allegations of infringement. And I think that's going to be the big question for the court. Is that enough, or is the law really talking about cases where people have actually been held liable for infringement in court? And I think we just don't. I think that's an open question.
We had Anne-Marie Brighty on the show last week, and she's quoted here in this Vox article on the case. And her opinion was that a court could find that repeat infringer is someone who's actually been found liable in a court of law of infringement, that simple allegations of infringement would not be enough to put an ISP on notice. What do you think of that approach, Margot?
I think that is precisely the crux of the issue, right? Is whether this is going to be due process as determined by the company that has every interest in the world in getting the person who's infringing kicked offline, or if it's going to be due process that actually involves the court system to some extent. And one thing I wanted to flag about this case, which is in the article but is sort of buried a little bit, is that it's a bizarre case because it's about a cable company. It's not about a website. So most of the places where there's been litigation over what constitutes a repeat infringer, we're talking about a website that does actually, to some extent, have knowledge of what its users are doing. But this, pushes cable companies to really be heavily monitoring what their users do if the holding ends up being that they're responsible for kicking repeat infringers offline.
So, Jake, you're involved in a company that is aggregating a lot of other people's IP, but I'm assuming that what you're putting together at Casetext will be your own proprietary IP too. So you have a dog in this hunt. Do you think that ISPs should be more vigilant in policing what their users are up to?
So quickly on what we're doing, we, of course, the only things we publish on our site are done with the permission of the authors to do so, and or done in kind of a snippet-like fashion, kind of like a short headline and a few words. And so hopefully I don't actually have a dog in this fight.
Okay.
But I do actually have an opinion on this, which is generally speaking, I think it's actually a kind of a savvy approach by BMG to force what was essentially their enforcement of their copyrights onto somebody else, and they're making them do all the hard work and also making them the bad guys. Because I think what BMG doesn't want, and I've seen actually some other leaked documents from other media companies in the MPAA, that they recognize how bad it looks for them to be suing individuals for copyright violations for sometimes hundreds of thousands or millions of dollars, and how that makes them into the bad guys sometimes. And I think part of this might be behind the scenes is an effort to try to find another sneaky way of making them get what they want, while at the same time not being the bad guys. And so I think that part of what's happening here is them hoping that the court will rule in such a way that the ISPs have to be the ones doing all the hard work of finding out what people are doing on their on their networks, and also have to be the ones who make the tough decisions about who to kick off and when, and be the bearers of bad news and so on, which I think is a very kind of savvy business strategy on their behalf.
Yeah, I think you've got a real point there. And I think you've also given me my first MCLE passphrase for this episode of This Week in Law. We put these phrases in the show in case you're listening to the show for continuing legal or other professional education credit, and you need to demonstrate that you actually watched or listened to your oversight board. So no dog for Jake is going to be our first phrase for the show. We'll put another one in before we're all set and done here. And also, if you need more information about applying for legal education or professional education credit, head on over to our wiki at wiki.twit.tv. And there's a page there for This Week in Law, and you'll find all kinds of information there for you. Let's conclude. I think we have concluded our Hollywood-oriented discussion for the day. Unless you want to go around, guys, and just give any final thoughts about the various developments we've been discussing that impact the entertainment industry. We'll start with Sarah.
I don't know if I have any profound final thoughts. I think it's interesting that the content industry is continuing to play whack-a-mole so much. And also just the larger theme of using copyright to solve these other problems. I think that's a big theme of the show, and I think a theme of the year. And I think it's an unfortunate development. But
Yep, excellent point. Margot?
Yeah, so I didn't get to talk about this with Garcia because there were so many interesting issues. But the big flag for me in that case was when Judge Kaminski started citing the Beijing Treaty on audiovisual performances. And I think the quick comment I want to make about it is that it is very problematic for a domestic judge in a domestic court to be referencing an executive agency's interpretation law going into negotiations of a treaty. Kaminski basically read the PTO's interpretation of U.S. law and implied that his decision deferred to the PTO's understanding, which was very, very strange and problematic.
Okay, Jake, any final thoughts?
Yeah, I think for a lot of these issues, the big question for me, and especially I have a kind of a personal self-interest in this now, but I've had one for a long time before starting Case Text, is how all this stuff affects the little guys, the small startups of 4 or 5 people who are trying to take on very large competitors. And that's not just only for things like net neutrality, where there's kind of an obvious connection, but also, I mean, when I read about the Garcia case, one of the things that scared me the most was the defendant is Google, and there are going to be a lot of legal decisions with Google in mind about how easy it is for them to take down certain things, how much administrative burden you can put on somebody. And for issues like that, I mean, for a small startup, again, of only a few people, if we had to face the kinds of problems they did in terms of copyright and takedown notices and a flood of kind of requests like that, it might totally kill us, or at least be a really big pain in the neck. And so, I hope that as these kind of policy issues continue to be discussed and developed, it's not just at the level of Intel and Google and Microsoft, but also how these kind of broader policy decisions and decisions about copyright end up affecting the companies that may one day be very big but start off very small.
All right. Well, we've already been discussing copyright, but we'll move away from discussing it in the entertainment industry context and into some broader context about now in the show. Can't tell you guys how excited I am that we get to talk about the monkey selfie one more time before 2014 is over. Yay! Christmas came early. And it came in the form of David Slater, the photographer who quite some time ago handed his camera to a monkey, a macaque. Is that what kind of monkey this is? I think it is. Who very beguilingly smiled into the lens and took a picture of itself. This has caused many a lawyer and law professor paroxysms of glee ever since in trying to decide whether there's a copyright in this photograph taken by the monkey. And if so, who does that copyright inure to? David Slater, the photographer, continues to think that it inures to him. He is in the vast minority when it comes to the legal scholarship on this opinion. And very recently, on December 10th, he sent a letter to Sherwin C. at Public Knowledge asking for sort of a confused laundry list of things to take place. Sherwin had written about the photograph and his take on the copyright issues at Public Knowledge. David Slater did not like the conclusions of that post, felt like it would encourage people to use the photo, which he claims he has the copyright in, and just did a mishmash of arguments about why Public Knowledge should take down the post or allow him to comment on the post and do another post. It's all kind of confusing, but it ends with him saying, if you don't comply with my demands, I will refer you to my lawyers and we'll take it from there. Sherwin C. issued a very well thought out response to all the points and basically told the photographer to pound sand, that we're leaving the post as it is, and we continue to think you don't have the copyright. And by the way, you're wrong on all of the salient legal points as well. So I'm just happy that we get to talk about beguiling macaques taking pictures of themselves once again before the year is over. And I will open this up to our panel to see if you guys have any further shades to add to this. Jake, have you been following along with this?
I have been. I'm not sure if I have much extra commentary to add to it. I love the picture, though. Every time I see it, I smile. But it's, I'm not enough of a copyright expert to say whether, I know for certain whether there's a copyright, for, whether the monkey owns the copyright or the photographer owns the copyright. I just think it's kind of a hilarious story. And I think actually it wouldn't have gone nearly as far as it did, like many things online, if it didn't include a cute animal involved. So
very, very true. Sarah, David Slater sort of mysteriously invokes Wikimedia and Creative Commons in his demand to public knowledge. It seems like he was kind of misguided there.
Yeah, I can't remember what his Creative Commons comment was, but the whole letter.
He says public domain is not a place such as Wikimedia's Creative Commons or the internet. So he's confusing a couple of things.
He's conflating both of them. Yeah. I think there were a lot of misunderstandings in the letter, not only about copyright ownership and that question, but then there's obviously, as Sherwin wrote in his response very eloquently, that there's a fair use. Even if you assume that he owns the copyright, they have an obvious fair use right to use the photo in the way that they did. Another interesting thing I thought about the letter was he talks about how use of the photo is hurting his commercial prospects. And I was thinking, just as a practical matter, that cannot be true, because so many people now want this image. It's become like completely ubiquitous. I have to imagine that his demand as a photographer is probably way up. So this publicity seems to me like it can only be helping the photographer. But
so one really interesting, maybe he's trying to reverse Streisand effect himself.
Yeah, exactly.
Any exposure is good exposure. One really interesting part of Sherwin's response to Mr. Slater is where he goes into the fact that the Copyright Office actually used this particular fact pattern, a photograph taken by a monkey, as its very first example of various kinds of photos that lack the human authorship requirement necessary to register copyright. And they also mentioned things like elephant murals, wave-shaped driftwood, or the natural appearance of animal skin. Again, this, I think, becomes a really interesting point in the times that we live in, the human authorship requirement, and whether it still makes sense or whether we're just going to have a whole lot of unhappy David Slaters out there, because more and more photographs are not being generated because a human clicked a shutter or pushed a button somewhere. If you have a GoPro, it has a setting where it's just on burst mode and takes some incredibly beautiful high definition photographs that, again, I mean, I suppose the photographer put it on burst mode and thus can argue that they have the copyright there. But all over the world, I mean, look at all the people looking for Bigfoot. Those cameras are taking lots of pictures in a very automated way. And one of them's going to capture Bigfoot, and somebody's going to argue the copyright in that photo. So Margot, in a world of increasingly automated photography, what do you think about the human authorship requirement? Is it still viable?
So I'm so glad that you pointed to this, because the entire time I've been watching the monkey news story evolve, I have been thinking to myself, and I'm not the only one, that this is actually all about robots. Because the fundamental question with the monkey picture is what counts as a work of authorship / what counts as original enough for purposes of copyright law. And as Sherwin pointed out, the Copyright Office now, and as you pointed out, now has said, look, when we're saying work of authorship, we mean a work of human authorship. And when we say originality, we mean something coming from human creativity. But actually, the regs don't fully answer the question. So we do, at least with respect to AI or robotics, so we do have a really clear description of things in nature not counting as works of authorship, or things produced by animals not counting as works of authorship. But then the example they give of something that doesn't count as a work of authorship and is mechanical is randomly produced weaving patterns. And there's definitely a continuum between something that's authored by a human, something that's authored by a human programmer whose intent is translated through a machine, and then something that is randomly produced and not copyrightable. So they haven't actually answered the question yet of everything else on that spectrum between human authors it and randomly produced through algorithm.
Right. Well, obviously, this is going to become a question. As you said, it's all about the robots. It's all about the drones taking photos. It's all about the comet landing space probe taking photos, and how copyright law is going to shake itself out, dealing with those realities. So we're happy to have one last occasion to bid our favorite monkey a happy new year, and thank you for entertaining us so much in 2014. I wanted to take the opportunity, since we have Sarah on the show, to congratulate Creative Commons on its 12th birthday, and just get your take on the state of Creative Commons, Sarah, and where things go from here.
Yeah, so CC turned 12 on, I think it was Tuesday this week. You mentioned last week on the show that in this next year, we're probably going to reach 1 billion licensed works, which is kind of an incredible milestone. I think it's really amazing that there are so many CC licensed works out there. I continue to get a glazed look often. I'd say about half the time when I talk to someone, especially now that I've moved out of the Bay Area and I try to explain where I work, I often get a glazed look, because I think it takes a certain amount of sophistication with copyright to even understand what Creative Commons licenses are and what we do. But I think it just reflects that, the public is becoming increasingly sophisticated about copyright, just because everything you do online, almost everything you do, implicates copyright. We just published, I think you're showing it now, the State of the Commons report about a month ago, which is a really cool, I'll put the link too in the Delicious list. It's got an infographic that kind of shows how far CC licenses have come, how many are out there, in what domain, what licenses are the most popular, that sort of thing. That's just kind of really handy and useful information. But yeah, I think it's a really exciting time to be at Creative Commons. So.
Yeah, and it seems to me that in the 12 years that Creative Commons has been around, you guys have done some very important partnerships where people are able to license their works very easily and, make one decision and not have to, in the case of Flickr, for example, you can just sort of make a one-time decision that, hey, yeah, I like this idea and I'm going to license my works in this way. And you can always go in and alter that, but it becomes very frictionless and easy for people to actually license their works and expand the body of work that's available for other people to reuse. So I think that's a super important reason that Creative Commons is going to license its billionth work sometime in the coming year. Margot, any thoughts about 12 years of Creative Commons?
Yes, I was a Creative Commons intern. I transitioned. Yeah, I transitioned out of the publishing industry into my current existence as a copyright law professor via Creative Commons. So all the best wishes to them. I think what they do is amazing.
Absolutely. Jake, is there any tie-in between what you do at Casetext and Creative Commons? Obviously, you guys would, I think, benefit from more works being licensed in this way.
Yeah, I would say, just generally speaking, there's an enormous kind of amount of gratitude and kind of debt of gratitude towards the Creative Commons. At the very beginning, even taking a step back from Casetext, a lot of what happens on the web that I think is the best stuff, people answering questions on sites like Quora and Stack Overflow. There's, people sharing information on Wikipedia. Creative Commons made all of that, all these amazing, community-based sites possible, and really made the underpinning of the legal infrastructure that makes sharing on the web possible. So I think that's enormously helpful. And for us in particular, everything that's contributed to our site is licensed under Creative Commons by attribution, and we do that in a way to communicate to our users that we're committed to the open web and to the sharing of information, which is a core tenet of everything that we do. And so I'm a huge fan of everything that Creative Commons has done. went to Stanford Law School in part to work with Larry Lessig, who then, of course, left immediately after I got there to go to Harvard Law School, and switched studying, copyright to corruption. But it's it's something I've been following for a long time, and it's something that I think is a large kind of underappreciated reason why some of the best websites can exist in the way that they do.
So Casetext, then, I didn't know this, is one of those sites that goes ahead and incorporates Creative Commons into its submission process?
That's exactly right. I mean, this is a minor point in our terms of use, although it's something that we probably should make a bigger deal out of. Everything, there are thousands and thousands of posts and inline annotations and other information being shared on Casetext, and all of that is Creative Commons.
That's great. Well, congratulations, Sarah, and Creative Commons. We're going to come back in a moment and talk about one of our favorite topics, drones and drone law. But we're going to first thank our second sponsor for this episode of This Week in Law, and that is FreshBooks. FreshBooks, in case you are wondering, is the cloud accounting software designed from the ground up for entrepreneurs and small businesses. I use FreshBooks in my practice. I have for several years now, and it makes all of my both accounting for my time, generating invoices, sending them out, and then getting paid just completely wonderful, seamless, easy, convenient. I highly recommend it, especially if you're someone who's still trying to cobble together timekeeping or invoices with Word or Excel or Google Docs. You've got to stop that right now and start using FreshBooks. It's the easiest way to create professional-looking invoices, and it takes just minutes. FreshBooks is built for growing businesses. On average, FreshBooks customers double their revenue in the first 24 months and get paid an average of 5 days faster. Are you tracking billable time with a watch? Billing clients for your time has never been easier than it is with FreshBooks. You just open up the app on your phone, you start the timer, and go, you're done. Avoid those awkward emails and phone calls to your late paying clients, because with FreshBooks, you get automated late payment reminders that you can set up to help you get paid faster and stay worry-free. You can set up recurring profiles so that you can put your billing on autopilot. Literally, you just go in with a few clicks, you enter your time for that month, you have it all set up to go to the appropriate person, and boom, it's out. FreshBooks customers spend less time on paperwork, freeing up to 2 days per month up to focus on the work that they love. Do you keep your receipts in a shoebox? I hope not, because now you can snap photos of receipts right from your phone to instantly capture your expenses. You can also instantly access complete financial reports so you can make smart decisions for your business. FreshBooks integrates with your apps. For example, Google Apps, PayPal, Stripe, MailChimp, Fundbox, and Zen Payroll. If you ever need help, too, you'll talk to a real-life person every time, and support is free forever. So you need to try FreshBooks free for 30 days with no obligation. Go to freshbooks.com/twill and enter This Week in Law in the How Did You Hear About Us box when signing up. Start your 30-day free trial and go to freshbooks.com/twill. Please don't forget to enter This Week in Law when they ask how you heard about us. That helps us a lot. Thanks so much, FreshBooks, for supporting this episode of This Week in Law. We're going to look at drones, and we're going to look at them on the law and policy side. So just a couple of episodes ago, we did a show all about drone law, episode 284, Game of Drones. We've got Margot on with us today, so I could not resist following up on some of those themes and discussing what's going on with the FAA and drone regulation in general. And also, Margot, you've written some interesting thoughts about the free speech problems generated by regulating drones. Can you fill us in there?
Sure. So this actually is going to tie back in a little bit with the conversation we were having about robots and copyright law. So as you pointed out, increasingly recording is automated, right? And drones are a classic example of this. If you have a quadricopter and it's got a GoPro on it and it's going up there and taking video, you do ostensibly have a videographer for that video who's the person who's operating the drone and put the camera on the drone. But increasingly, there's some sort of machine action that's happening in between there. So the First Amendment issue arises because there have been an increasing line of cases that recognize a First Amendment right to record. And then in those cases, the courts are really dealing with situations where people take out their cell phones, see police officers doing very bad things, which police officers never do, and take videos of them on the cell phones. And so courts have been finding that, when cops then subsequently arrest them for violating wiretap law or eavesdropping law because they've picked up on audio conversation without getting permission of the people who are being recorded, the courts that have considered this have, for the most part, said there's a First Amendment violation. You can't arrest people for just for recording a public official performing public activities in a public space. So, of course, the question this raises is, does everybody who has their drone and is video recording anything with their drone have First Amendment protection? And it is an extraordinarily difficult thing to try to figure out.
Well, I think we should go ahead and make it, because it's such an extraordinarily difficult and important issue, our MCLE passphrase, so that people can remember it. We'll call it First Amendment drones as our second passphrase for the show. And Sarah, this is not a topic that we touched on a couple of episodes ago when I had our drone panel on. So I'm wondering, obviously, as drones and automated technologies of various kinds become more and more a part of day-to-day life, do you think that the regulation of them should, as Margot's pointing out, bear in mind that the First Amendment needs to be taken into account?
Yeah, absolutely. I saw Margot's Slate. It was a Slate article, I believe, in my Twitter stream when it came out, and I just remember thinking, wait, drones and First Amendment? That it wasn't intuitive to me, but of course, when I read it, it makes perfect sense. So yes, I think it's absolutely a First Amendment issue, and a tricky one at that.
Is there a tension, Margot, between the First Amendment issues that you flesh out, and for anyone who wants to read Margot's whole piece, it and everything else we've been using as the basis of our discussion today is available for you to check out at delicious.com/thisweekinlaw/286 is our episode number this time. Do you think that there's an irreconcilable tension, Margot, perhaps between privacy issues and First Amendment issues?
This is basically what has been occupying me for around a year and will continue to occupy me for the foreseeable future. I don't think it's irreconcilable. I think that what's really difficult here is that we're in a country, as you can see from the Garcia case, where we believe very strongly in free speech protections, and we have a First Amendment that tends to be very absolute when it's applied. And so if you afford people the strictest kind of First Amendment protection for these videos, it is unlikely that a privacy law would withstand that kind of scrutiny. It's not impossible. There's Supreme Court precedent around wiretapping in Bartnicki v. Vopper that suggests that the court might be open to considering, that a wiretap wins out against the First Amendment. But it is a balance that is really difficult to imagine the current Supreme Court making. That said, I think you see in the Supreme Court's privacy case law very strong awareness of the importance of privacy in private spaces. And so at least when you're dealing with the combination of filming and trespass, you may have a stronger case for banning drones from wandering into private land than you do banning drones for capturing private moments.
Jake, are you still based in Palo Alto? I know you were at Stanford. Are you still in the area?
Yeah, we are. We're actually not too far away from Stanford's campus right now.
So do you just walk around with a fly swatter to make sure no low-flying drones are, bonking into your head?
You don't see them as much as you think actually around here, although you see more of them probably than anywhere else. I actually have a friend who's starting a startup that's actually, very, very new, but it's a, drones as a service startup where, the funny thing is it's all entirely illegal under, I understand, the FAA policy, but, that's just the way Silicon Valley is sometimes with the Uber and Airbnb as well. but they essentially will. I forgot the name of it, and I think it's not online yet, anyways. But they'll essentially, connect somebody who wants pictures being taken by a drone, or a video being taken by a drone with people who are drone enthusiasts who will help you do that for you. And then one of their early clients, as kind of in their beta testing phase, was a hedge fund that wanted a drone to fly over the Walmart parking lots during this holiday season to see how many parking spaces are being filled up and how long people are shopping there for. And I think that's just fascinating stuff. Again, I think it's entirely illegal. I may be wrong about that because it seems like it's being used for a commercial purpose, and I think the FAA won't allow that for a while. But at the same time, it's definitely being done, and there are questions about, I think the trespass question is interesting. Can Walmart be like, hey, get off our land, don't take pictures of our cars here? Or what happens when one of these drones, runs out of batteries, falls out of the sky, and hits a car or a person? I think it's all quite interesting.
Well, the Washington Post thinks that the FAA won't make up its mind on those commercial uses until 2017. Margot, do you think that that's an accurate prediction?
Yeah, so we had news around a month ago that the FAA actually, this was also via the Washington Post, the FAA has actually finally drafted its rules for commercial drone use. And as Jacob pointed out, commercial drone use right now is not legal unless you've gotten an exception from the FAA, which I think it's given to roughly 10 companies. But all of those wedding photography companies that are filming people's weddings and crashing into the groom are doing so illicitly. There's a great viral video about that, by the way. I should have included that. Anyway, but the FAA has apparently, again, this is from the Washington Post, drafted its rules on commercial drone use based on the model handbooks that it gave to those 10 companies it did give permits to. What is really problematic for people in this field is that those are very stringent rules. They involve a limit on how far up the drones can fly. They involve getting professional pilot licenses, which seems ridiculous if you're dealing with something that's, 10 pounds and operated on your cell phone. So they're going about this very slowly, and those rules are currently sitting with the White House, which was supposed to say something this month about them. And then they'll go through the extensive notice and comment period, and that is why we're predicting it's not going to actually be fully enforced or fully in place until 2 years from now, 2017.
All right. Any final drone thoughts from anyone? Sarah?
No, not really. I mean, I guess the only thing I would say is I'm sure that the delay, as that article talked about, the delay in rulemaking will hurt some companies that really want the certainty. But then, as Jake points out, it won't hurt others because some people are just going to plow ahead. So,
right. And grooms will at least be protected under the law for a little while longer, even if people are buzzing into them. There we go.
There you go. It's amazing.
Oh,
yeah.
It's just awesome.
Gosh. Slow motion.
Oh, and so now we're looking down the bride's shirt as well from the drone. All kinds of wonderful drone-y issues raised by that tiny little clip. All right, let's move on. I want to talk with Jake real quick because we've been referencing his company all show, but not really talking about the interesting approach that they're taking that I think people who listen to our show would be fascinated by. It is not a nonprofit company. You certainly have a business model, Jake, that involves people paying for sort of, I guess the model would be freemium, right? A lot of your content is for free, but some of the more enhanced features will be for a paid subscription that will then underwrite the rest of the access that people get.
That's exactly right. I mean, right now, everything on the site is 100% for free. And we actually have, behind me at my desk at the office, there are our company values. And the one that's in the top in the middle is the law is free. And the law for us will always be free. So we're not going to do what Lexis and Westlaw do and put the primary sources of the law behind a paywall. And also everything that's ever added by people who contribute to the site, that's also always going to be free. The model, as you describe accurately, is freemium. We have investors who very strongly believe in our mission and are thankfully we get to do what we're doing now completely for free as we continue to build these features. But there are going to be things like advanced research functionality, things that make the research experience quicker, faster, find the most important parts of it quickly. We're also going to actually have, we're talking with a lot of law firms right now about a private version of case text. So right now people can share what essentially look like blog posts or inline annotations on cases. A lot of law firms have approached us and said, what if you had a version of case text where we can upload our briefs, our memos, our internal dialogue about the cases and statutes, but that's shared privately only within our firm. And that's something that we're also going to offer, although it might take a little bit of time to build that feature set, so that the next time at your law firm you pull up a case like Massachusetts VPA, you get to see all of the interesting briefs, memoranda, people who've worked on it, et cetera, that your firm has added.
Great. And the next time Sony gets hacked, there will be an even bigger wealth of information.
That's right. That's right.
To look at because of all the annotations. All kidding aside, I think it's a great concept and wonderful service that you're going to provide. Tell us more. You mentioned earlier you plan not just to incorporate what has always been thought of course, the primary sources of law, the statutes and case law, but also a lot of commentary out there that from people, for example, like Margot, who are filing amicus briefs in important cases and writing their own thoughts about those kinds of issues in other sources that often aren't captured or citable or necessarily that accessible. So how do you guys plan to incorporate all that?
That's a great question. I mean, first I should say, when I practiced law, I worked at a big firm, and I'd always start all of my legal research not on, the big proprietary systems, but on Google. And the reason I did that is I would always find something very smart written by either a law firm itself when they have these things called client memos, which are essentially basically blog posts that describe what a court held or an evolution area of law, or from professors like Margot, where there are many of whom now blog with regularity and have very insightful things to say. And that was always kind of the best way for me to get a very good lay of the land of the area of law or the specific case that I was researching. And, I've always thought, wouldn't it be interesting if when you were doing research, you can automatically see all the interesting things that have been written about the case that you're currently reading from all over the web. But even better, what if you can, and this is something we're working on right now, what if you can discover the most important sections of the case? We have something called the heat map, which points you out to, it gets kind of darker blue, the more important of a part of the cases you're reading. You can see it alongside the left side of every case. But we also, are going to incorporate into the heat map and do a few other really neat things to say, okay, well, of the 50 articles written about this recent Supreme Court case, 48 of them were talking about this one sentence. So this is probably the sentence you should look at first. This is the operative legal holding, or the key fact, or the really interesting break from precedent that this case should be known for. You can do a lot of very interesting things. You can take all this wealth of information and commentary that's happening on the web and use it to make the legal research experience better. And I will go so far as to say, we are at the very beginning of what we're doing right now. There's a lot of plans for the future, some of which I can share and some which are kind of under wraps. But one of the things that we're working on a lot over the next, few weeks and months is making the writing experience on case text particular for law, and make it a better place to publish these kind of thoughts and comments about recent cases, about changes in statutes. And one of the things that we did first is we launched what we call a communities platform. We did that about 7 weeks ago. And there are thousands and thousands of people who are quote unquote following communities. And what that means is you can see as a follower, you can see all the interesting things being added to the site. And as a writer, it means exactly who your audience is. Yeah, that's exactly right. So it's kind of incredible how this kind of grew overnight to having thousands and thousands of followers for these communities, and it's growing at an extremely rapid clip. And actually, if you click on the number of followers in any of these communities, like for the business law community, one thing you'll see is the people who are following these communities are the kinds of people who I think are very kind of targeted group of very interesting people. They include general counsels at law firms, partners at general counsels at companies big and small, partners at law firms, law librarians, law professors, and it means, that what we hope we're building, besides just a better writing experience, is the best way for people to connect their commentary and thoughts and ideas to exactly the kinds of people who you likely want to be reaching.
I'm so glad you just gave us such a nice description of Casetext Communities, because it is one of our resources of the week here in our final show of the year. And if you go and you check out each of these topical areas that Jake has been discussing, you'll see a really nice news feed of everything that relates to that topic of law. So, of course, there's a privacy and cybersecurity one, a tech law one, an IP one, a patent law one, all, of course, a copyright law one, all very important to the topics that we discuss on this show. So very neat resource, and I encourage folks to check that out. Of course, as Jake's been pointing out, everything on the site is free for now, and lots of it will remain free, as I understand, once their subscription services kick in. So that's very cool,
exactly right.
Jake.
The free stuff, expect the free stuff to remain free essentially forever. And for the new things we put behind paywall, they're going to be even more advanced uses of data science and informatics to really make the research. It's essentially targeted at people who have the means and the interest in having an extremely efficient legal research process. But right now, you can in perpetuity use the tools. And I should point out actually about the communities, one thing that is interesting to note: if you sign up and follow them, you will have a personalized newsfeed that's the combination of all of your personal interests, like tech law, copyright, IP. And if you choose to sign up for it, you'll get a regular email digest that says, here are the things that have been upvoted by your peers in these fields that are the most interesting, today or this week. So I think it's a really good way of keeping up to date with all the interesting things happening in the law.
All right. Thanks so much for that. Hey, our other resource of the week is just kind of for fun. Mashable did a best drones of 2014 video. So I thought maybe we'd just take in a bit of that to see, other than crashing into grooms, what drones have been up to this year. As with the rest of our discussion points today, the best drones of 2014 is over at Mashable, and you can find it in our list of delicious links for this episode. I don't think it included the conked on the head by a drone at your wedding. Keith Stryer, who we had on the show a couple of episodes ago, pointed me toward one more that was a falcon attacking a drone and bringing it down that he thought was memorable. So it's been a good year in drones. We usually end with a tip of the week, but because this is our concluding episode for the show, I thought I'd go around and let each of our panelists, looking back on the year, see if they could distill out a tip of the year that they might leave you all with. Margot, can we start with you?
Sure. My tip of the year is watch out for unintended consequences of accidentally regulating information technology. And I'm drawing from the FAA's experience of suddenly realizing that it's regulating information technology where it was used to regulating airplanes.
Excellent point. Sarah, how about you?
My tip was to, if you haven't heard of it, to look up the Authors Alliance, which I don't know if you've talked about it on the show before. I haven't heard you talk about it, but it's an organization started by Pam Samuelson and Molly Van Houweling, who are two women I admire deeply. And the idea is to have a group that represents authors who want to be read. And they're doing a lot of really interesting work. It was just launched in May of this year. So that's something to watch for next year. They've got all kinds of resources. They're doing a lot of policy work. It's a really cool new organization. So.
And Jake?
My tip of the year is that what you write on the computer is becoming increasingly important. And I mean that by there's the downsides, which is we see in the Sony hack, all the stuff you thought might be private becomes public. So you should definitely only commit to writing things you're very proud of. There's also a positive side too, which is, one thing that kind of pleasantly surprised us when we started Case Text, and some things you see in other fields of different professions, is people are building kind of a real reputation and really standing out in their professions and with their peers by sharing, information about themselves or their thoughts that are really kind of thought-provoking and interesting. And so, I think people should be more cognizant and think a lot more going forward about the things that they write online and how important that is, both on the kind of the downsides and the upsides.
Right. It's kind of like the rule of thumb. If you put it in an email, just go ahead and assume that it's not going to only be read by its recipients, right? Yep. As though you're always writing for a public audience. I think that's great advice. My tip of the year has to do with the trend that we've seen all year toward, and I think it's a really positive trend, of private companies making privacy and security a selling point, of companies telling you that, we're going to keep your data secure and that's why you should use us. But my tip would be to push back hard on those claims and make sure that if someone is telling you they have end-to-end encryption and no backdoors, that's really the case. And don't just be taken in because this is a popular marketing approach at the moment. It's a very positive development, but keep your skeptic's glasses handy when you're considering those claims. And with that, we're going to go ahead and wrap up This Week in Law for the year of 2014. My dad likes to talk about who you would... Who's on your imaginary fantasy guest list of dinners with interesting strangers? And I'm so blessed that I get to play out that scenario every week here on the show. I'm always getting to have great conversations with interesting strangers and friends, and this has been no exception. Thank you so much, Sarah Pearson, for joining us this week and for joining us on a regular basis coming in the new year.
Yeah, I'm really looking forward to it.
I am too. Margot, great to have you back on the show. Enjoy the holidays.
You too.
Good luck with everything that you're working on, which is extensive. We will continue following along with all of that. And Jake will continue following along with Case Text, which sounds like it's both revolutionary and interesting, and can't wait to see where you go with it.
Thanks for having me also. This was a lot of fun.
It was really a lot of fun for me. And it's a lot of fun every week. We do the show on Fridays. Our next one will be on January 9th when we pick up in the new year at 11 o'clock Pacific time, 1800 UTC. Actually, it's 1900 UTC this time of year. And that's when you can join us live to see the show recorded. You can jump into our IRC and play along with us. We love it when you do that. But don't worry if you can't. Because assuming that the Twit network isn't blocked on your Roku device or anywhere else, you can pick us up whenever and wherever you like. You can go to twit.tv/twill and find our show page, and our whole archive is there. We have a YouTube page at youtube.com/thisweekinlaw. And you can find us there too, and on iTunes and on Roku, as I mentioned. So definitely tune in when you can, where you can. Just join us. We love it when you do. As I said, our discussion points are available for each show at delicious.com/thisweekinlaw. And then the episode number, this is 286. And you should definitely get in touch with me over the break. Let me know what you've liked about our programming during the year, what you'd like to see in the new year. I'm Denise at twit.tv. And let me know about guests you think we should have on, topics that we should cover, things that you're finding interesting at the intersection of technology and the law. And I wish you all a very happy and safe holiday season, and we'll see you in the new year. Take care.